Okay, we're just about ready to start. Does everybody have a copy of all the handouts? Anybody that one kind of thicker one stapled together, and then there's about 5 additional ones?
Alaska's package.
Yeah, I'm sure. If anybody doesn't, just holler. If anybody can't hear us, we are trying to webcast this, and we have a microphone here sitting on the desk, so hopefully that will help. I don't know what. I don't think there's any speakers in here, but it'll help the remote people hear us. So Trish will let us know if they're not getting heard. Well, as you know, this is not your typical risk management meeting. We're trying to go over TRID. Sharon and I have put some material together of our best understanding of TRID. There are still some things we probably have some questions on, and I'm sure as you ask questions, there might be additional things we find out we have questions on. So feel free to ask questions as we go along, and we'll try our best to answer them, and if we don't, we'll write it down and we'll get an answer to it, okay? The first thing I think to know is that TRID is the TILA, which is the Truth in Lending Act, RESPA, that's the R, which is the Real Estate Settlement Procedures Act, integrated disclosure. So there's the basic thing here is they're combining the truth in lending and the good faith estimate, which is a good thing. A while ago, they changed the good faith estimate, but kept it separate from the truth in lending. And at that time, there was a lot of talk that they should be combined. In my experience as a lender, having those as separate forms has always been very confusing for the customer, because the Truth in Lending Act required disclosure in one way with grouping of numbers in one manner, and the good faith estimate grouped them in a different manner, so that the totals of these groups never added to the same number, and it was always very confusing for the customer that they did not. So putting them together in one form, I think, is a very good thing. And I do think the new form is easier to understand than the old form. The other thing that comes with this is that there are required areas where there can be no change between the initial loan estimate, which is now taking place, of the good faith estimate. It's just the loan estimate. There are a number of areas within that that cannot change between the initial estimate and the final closing. That's a good thing. There are many items within the loan estimate that cannot change between the initial loan estimate and the final closing. The things that can change are things that result from a changed condition, and that has to be, they have very defined legitimate changed conditions. Or, for instance, let's say someone's credit score totally changed between the time you initially estimated or the end, or you did an initial estimate based on a single family house and then they decided to buy a duplex. That would be a changed condition. At that point, the lender still only has 3 days from the time they know of that changed condition to issue a new revised loan estimate.
John, I have an example of a situation that occurred, and this is a daily occurrence for us. A closer spent yesterday with the lender preparing the current HUD with all the numbers and all the pertinent information to get prepared to close today. And both lender and closing entity found out late yesterday that there was an addendum changing the sales price that neither the lender or the closer knew about. So pertinent information affects what they've done. And so those days of, oh, by the way, you know, everybody changed the price and we did an addendum, but we didn't provide that, is going to be these type of things that John is talking about, that they're pertinent changes.
Yeah, and that unfortunately happens way too often, as we all know, and there's a lot of people in the process, and the handoff of the football from each person, there's a lot of ways that can be fumbled. Fortunately, that type of change would not require a new 3-day waiting period.
Okay, what was the change?
A
Change of
in
price.
in the price. So what kind of waiting period would there be?
That would still be a 1-day waiting period because you cannot, it's really, they don't call it a waiting period, but you can't close on the same day that this CD, closing disclosure, is issued. So you'd have to do a new change circumstance and a new closing disclosure, but then you can't draw your note that day. It has to be the next day. So there'd just be a kind of a 1-day wait in that process.
Okay, so a change of price was only a 1-day wait.
Should be, yes.
And why would, what constitutes a 3-day?
Anything that changes the APR. Now, if it changes the APR down, that's not a problem. But if the annual percentage rate goes up by more than an 8, that would do it. The addition of a prepayment penalty, which we don't have in Alaska, so that shouldn't be an issue up here. And the third thing is if you change the loan product, which hardly ever happens. You're changing from a fixed rate to an ARM or to an FHA loan. You're changing the type of loan you're doing. Then that would normally require a new 3-day waiting period.
So, but if the change in price actually required a new loan amount, if that was the intent, then that could.
It could if it changed the APR. But if it just changed the loan amount but didn't change your APR, then that shouldn't be something that would require a new 3-day waiting period.
So there's some real nuances to this.
There's a lot of nuances. There's also what defines, we're calling it a 3-day waiting period. But in reality, in many cases, it can be 6 days. And the reason is that the 3 days starts from the time the customer acknowledges receipt of the closing disclosure. So the lender's going to have something in their file that shows this is the date the customer got that closing disclosure. Then you have to wait the 3 days and disperse. Then you can get your loan documents out or consummate the transaction, they call it. If the customer does, I believe the normal way it will happen will be the customer will get an electronic notice of this because that's the fastest way to get to them. They will sign they've gotten it, and now that starts the 3-day clock. If they don't do that, they can either come in person and start the 3-day clock, or we will mail it, in which case there's a 3-day presumed receipt for mailing. So that adds those 3 days to how long it takes for the customer to presume to have been in receipt of that closing disclosure, and now your 3-day clock starts from there. So that would be a total of 6 days in the waiting period. Does that make sense to everybody?
So when before we have a closing, I understand correctly. Before we have a closing, signing documents, you, the lender, let's say, email the documents to the buyer.
Mm-hmm.
Okay, and the buyer acknowledges that they received your email.
Mm-hmm.
And then there's a 3-day period that document sits in limbo, they review it, they make decisions, they do whatever. If there are no changes, you can record after the 3rd day.
You can consummate the transaction, which means sign the note and the deed of trust. So let's say the customer received the closing disclosure on Monday. And typically you would sign the deed of trust and the note on Thursday and record on Friday.
What are you sending them on Monday?
The closing disclosure.
And that is?
You'll get, it's one of these many
That's this 8
forms. Yeah.
Okay,
Yeah.
so this is what they get on Monday.
Yep.
There's 3 days, and then they come and they sign their note to do the trust. That's actually closing.
Right.
Okay.
And you have a flow chart here of this process in this here. So, these are all new thoughts, but a lot of this, as John and I were talking about, these are really changes that are really coming and placed on the lender.
Correct.
We then have a flow to you and to the closing process. So today what we're trying to do is get you this perspective of what the lender is now required to do for the borrower, and then what do we see here as it flows down and we really get it closed? What kind of documents? I gave you a sample of the flow chart a sample closing disclosure that the borrower gets, a closing disclosure that the seller will receive. And these are the type of settlement statements that you will now be reviewing and looking at about the transaction. So we're trying to give you some samples of what your new world's going to look like.
Go ahead.
I think it's important to note that in those 3 days, Sundays do not count as a
Correct.
day.
Correct.
Yep.
Business days, but Saturday is a business day and Sunday is not.
It is really important, and that's why this flow chart, because these are all new thoughts and new timelines. The flow chart we felt would be at least helpful to try to get you the review, the CD goes out, the review, when they sign, what counts, what days do count, what's the consummation, that's the signing of the note. Already there's been questions whether that's the recording date or is it the note signing date.
So,
Am I to understand that this time frame is carved in stone? I mean, assuming that everyone involved with the transaction is happy once the paperwork is delivered, is it possible to waive this period or shorten it?
no.
Absolute. Good question,
Good
Dave.
question. And Saturdays and legal holidays are not counted in counting those dates. Sundays and legal holidays, excuse me. Yes, you're correct. So we've handed out a number of things that kind of give the examples of how these dates are counted. I've given something at the start from NAR. We actually have a recording. I don't know if we want to play it now. That's from the National Association of Realtors that they gave on a little bit about TRID and how it affects the realtors.
It's about, what, 8 minutes,
About
10 minutes?
We'll go ahead and do that now.
And then we could,
On this flow chart, am I reading this correctly? If you do financing, Saturdays are a black.
Since we're not refinancing, can we not have to, we're dealing with
Because
taking people.
our clients actually have to know this. I have my refinance too.
Yeah, but what you want your clients to do is talk to the lender, not you try and interpret it for them, in my opinion, because you'll just, the odds of being not accurate are probably not good.
this is so new for everyone. I think it's important that this really, this is informational, it's to prepare you, but it is in the focus of the lender to perform this. And of course, you want to know what they have to do because you deal with all the parties. But even for us, it's an ongoing kind of a changing. That's why it went from an absolute date of August 3rd to now October 3rd, because these fine lines are really being defined. Even here, John and his crew are under training with their new software to prepare these. And so there's a lot of learning curve going on, but we want to get you prepared for as far as we've gone. So I think it is hard for someone until you get into this deeper to really even explain it very much.
I think like everything, once we get into it,
Yeah.
It's not going to be that hard for us all to adjust to it. I think in some ways there's some real good aspects to it. When I know title is actually looking forward to the fact that when people come into closing, things can't change. It can't change legally, so that's a good thing.
It is.
The negative to that is sometimes you don't intend for things to change, but they do. Sometimes
That's life.
someone comes in and, oh, I've got a power of attorney. And that power of attorney needs to be recorded. Now you have, because of the recording of the power of attorney, that your recording fees went up by a few dollars. We had one deal, this was even before this act was in effect, where
I knew you were going to
that
bring
happened.
this up.
And actually it threw us out of tolerance because we've had tolerance cures on this stuff for quite a while. And that loan could not be purchased because of the change of about $25 in recording fees because of a power of attorney. And we had to go back in, and you only have so many days to do that, to cure that, or that loan would not have been purchasable forever. So because of this extra $25 fee that we didn't even know about, that
And the
got added
closer,
on.
and the closer was handed at closing that.
Yep. And so it
Yep.
was a deal where we could have had a $250,000 loan that was not saleable because of that little tiny fee. So that's where the details become so very important to us, because many of these things have zero tolerance. And if you don't find out that you are out of tolerance until beyond the cure period, then you can't ever cure that loan. So that's the big deal.
I have a question. Since this process is starting like this, is there a way, like a transaction particular from your processors, for all the lenders, when we'll do this, for the buyers as well as the listing and selling agents, you can say, okay, we're in the this is how it goes in the beginning, just have a letter, a generic letter saying, this is how it works. We're in the process, we're in your day one, no changes. Can something go out so we can just forward it, or it goes to the buyers and the sellers and the listing? So it's a transaction particular, so they know, no change.
Yeah, I think we're going to get more and more of that as, you know, as we get real comfortable with the process. The problem is some of these, for instance, there's things like, you know, this is not based on the date. This starts on October 3rd. So it's not contracts written on or after October 3rd. It's applications taken on or after October 3rd. And an application, though, has to have a property. So if you had a deal that you had the contract and the lender had the application and started on September 29th, but it wasn't closing till later, then TRID is not going to be in effect for that deal. It's only applications taken after October 3rd, and then you have to go through the definition of application to determine if that transaction is included in this or not.
And John, aren't you at this point in time with all of your team and all of your lender commitments, putting your packaging together that would have this type of information? We're all still trying to, we're waiting for this whole alignment of the stars with the lenders with all their new documentation. And I would assume some of the things she's asking would be addressed in that package.
Sure. Another thing we're looking at is, for instance, on this electronic disclosure, the customer has to agree to electronic disclosure. You know, and all the stuff you get these days for Privacy Act and everything else, they are, you know, your credit cards, everything else is sending you a notice. Do you agree to electronic disclosure? If you don't agree to electronic disclosure, they have to send it to you in the mail. Most of us don't want to get it in the mail. We want to get it electronically, but you have to agree to it. And then that creditor has to have it in their file that you agreed to electronic disclosure.
One of the things, I've listened to so many seminars, and like you said, it's been changing constantly, and I actually see the last time I went to the conference. But do both, say there's two borrowers, do both have to acknowledge the closing disclosure or only one?
I believe both borrowers, my assumption is going to be both borrowers have to for right now. If you have a POA, I believe you can acknowledge it in that way. There are some differences on what we can use for power of attorney and stuff, but we're just trying to sort all that out in this process also. But the important thing is very early in the process, we are all lenders, I think I know we have a form, and all of our originators are going to be getting a notice out to the customer saying that they agree to electronic disclosure. Because there's a lot of things that have to happen if there's what we define as an application, even if it never turns into a deal on refinances and everything else, that we have to have this electronic disclosure notification, and that will certainly speed up the process.
So with that $25 POA charge, would that be a 3-day wait if that happens?
It wouldn't be, because it didn't, in that case, it violated tolerance cures. Once we know about it, we just ate the fee because it was not within the tolerances. So we'd much rather eat a $25 fee than eat a $250,000 loan, as you might imagine. It wouldn't affect the 3-day because it wouldn't, unless it kicked you over
The APR.
the APR. But because it's a tolerance cure, you can't charge it by definition, so we would simply be eating that charge and not charging it to the customer, so it wouldn't affect the APR at all. Otherwise, sometimes a very small thing can be the final thing that kicks you over that 1/8% limit for a new 3-day right of rescission, and not right of rescission, 3-day waiting period.
And that's just an example of, at any point in time, that is why our closers, we are working closely with the lender, and we have to have any changes on, even today, before this, on the HUD, we have to have a HUD approval from the lender. They have to know if these numbers are changing, not just because of this new law, but because of their tolerance cures and things like that. So this has always been an issue for our closers when things come in late and it changes, which is part of life, because some of your transactions change, but they have a cause and effect even now, let alone.
And I think that's a very good point. That the biggest thing I think we're looking at on this is just trying to get it right. It's not a matter of, it's these little things that are going to kick you over some tolerance cures and stuff that all lenders are going to be looking at very, very closely. So when there's a change at closing, the biggest thing is it's going to have to go back through a process to determine that, yes, that's okay, we can have that change. It can't be just, oh, we're going to do this, let's just change the HUD at closing. That isn't going to happen, because it's going to be too hard to know whether that is something that kicks in, some sort of tolerance cure or something like that. John?
Does the closing disclosure come from you?
Yes, comes from the lender.
This does not take the place of the HUD.
There is not a HUD now, but you'll notice in some of the stuff that Sharon handed out, there is a ALTA settlement statement. There's one for a buyer and one for a seller. And those will be in addition to the CD. All of the numbers on these settlement statements have to match the closing disclosure. There can't be any change at all between those.
And so I gave you this package. Maybe it's a good time to jump in a little bit, just so that you would understand and recognize some of the new documents. This is the closing disclosure that the lenders are preparing. And this is what the borrower, the applicants, sign. So it gives you a pretty good idea. There's some similarities in your HUD document, or old documents. You can see where they combine these two. So this is your closing disclosure that the lender prepares and documents when they received and when that went out. This is, as you see, on this closing disclosure, there's all the parties involved on the back page. It shows all the parties, license numbers. There's lots of information on this for you to take a look at. But it's only the borrower who signs that one. So we have a closing disclosure that the seller would sign, and it's an abbreviated one with just their information. Again, those would have to be matching all the numbers on the borrower's disclosure. And then, because we still have to disperse, we have settlement statement for borrower and seller. So these are a sample. We have our software. These are coming off of our new software. We are still ourselves in some glitches. We haven't been able to print out. I've got one that's a draft filled out for you, but we're having issues with our new software of just getting things in the borrowers. We will have settlement statements with Alaska all over them, but these are the adopted structured documents that our association is working with. So it's helpful at this point in the game for you at least to get familiar with what it's going to look like. And again, we do the settlement statements, and we'll have our disbursement sheet and disperse. And so one of the questions we had asked, of course, with John and their process as they're learning it is, our software actually goes into every one of these screens. And we're not filling this out, are we? And so when we got our software, we are having some of these questions, but we are able to go in and then input our information in our screens to produce these other documents. And the lenders will want to see these final, that's going to be a complete package that they will want as always, not just a closing disclosure back to the lender.
I think one of the benefits is that the CFPB has regulated these documents that every title company across the nation has to use the same font, same look, same feel. So each and every one will be uniform, and that was really to try to get everyone on the same page.
This is a true standardization, yeah.
The loan estimate and the closing disclosure truly can be compared side by side in a very user-friendly manner. At first, it's a lot of information, but when you start to dissect it, it becomes very understandable.
The interesting thing is the old good faith estimate, which they revised, and we had to change all the computers to work for that, didn't have an APR on it. It didn't have a cash to close on it. And it didn't have actually the borrower's payment on it because it didn't have taxes and insurance on it. So the three things that are most important to the borrower weren't even on the GFE. Fortunately, in this new closing disclosure, all those things are there. So that's a positive change.
Hypothetically, you have a as-built survey come in before the end of the process. The role for that is going to be paid at closing. Goes to you now and not to the title company?
I would say yes, because we're going to do the initial and then they're going to come back to us. It'd be better if it was on that closing disclosure. Whether that as-built survey bill has to be included in the finance charges depends on what kind of loan it is and whether it's required for the loan. Because if the as-built survey is required for the loan, then that fee is as a fee that has to be on the closing disclosure and included in your APR calculations. If it's not required by the loan, but simply something that the buyer and seller agree to provide to each other, then it has it's in a different category. So that's one of the problems is the same item can be in a different category on a different kind of loan.
Typically, that's the seller cost, so that probably won't affect the buyer.
The seller cost wouldn't affect the buyer at all, but if it's a buyer cost, even then, it depends on the kind of loan as to whether that was required or not. For instance, Alaska Housing requires a updated survey within a year. So since it's required by the loan program, then it goes in a different category. And that's hard for us too, trying to figure out on every different type of loan, some of these fees route to different places. So that's another one of the programming challenges. Mike?
If we're gonna get into protocol, are you guys not gonna get all the bills?
Anything that's to be paid at closing, we should get, absolutely. Yes, yes. Bill saying send a boat, and that's not a bad idea, but, you know, the title people are, yeah, we want them to.
Well, and I think it's just, that's such a great point. It's just at this point in time, beyond the proactive approach of trying to get, because your life is, you have your part of this and your life is different. You're dealing with the buyer, the seller, the situational that make these things happen, these changes happen. And so being very proactive of getting everything, how you process your files, anything you have at this point in time just takes you that further ahead. And because we don't know how everything's shaken down, it's best to have gotten everything to both parties as much as possible. And then we know there's going to be exceptions to it. There's going to be other things that come your way.
Another point is someone had asked, and I think was concerned that on this closing disclosure, there is a place for commissions. And if that changes, is that going to affect it? Well, typically not, because that's not going to initiate a new 3-day because, number one, it's usually paid by the seller. But there are some realtors that are charging real estate commissions to the buyer. Now it's a buyer cost. Since it's not a required loan fee, it still wouldn't affect APR for us, but it might affect the borrower's cash to close. And we've actually seen some situation where at the last minute we get this thing, oh, the buyer owes a $700 fee to the real estate agent, and we're okay with that. We just need to know it because we have to put it into their cash to close calculations. And sometimes you might think that that wouldn't make a difference, but there's a lot of times it does. It changes whether they have enough cash to close. And all of cash to close has to be verified before closing. So it can disrupt a deal, definitely. Another thing I found is on that area is new construction a lot. All you that do new construction are going to really have to be aware of this because, you know, these change orders and things that happen during the process might affect, they come in at the last minute because the builders just getting together what all these change orders cost, that can affect the deal because that can affect the buyer's cash to close.
Especially with your, when you're talking about, either going to be on there with transaction coordinators. Fees that go to coordinators, whether it's with this company or another company. The seller's not made aware that they hear about it during a listing appointment, then when it comes at the end, they're like, well, what do you mean we have to pay another $250? I'm paying you commission. And that could really not only mess you, because we're the selling agent, and if that happens, that could postpone them. So hopefully they engage with their seller way ahead of time to remind them about that $250 that it's going to be on that sheet.
If it's paid by, in addition to, sometimes I know it is and sometimes it's not. So it just depends upon your particular deal. And that's another deal where every transaction is a little bit different and we have to be aware of that and be looking for it.
So for 1031 exchanges, very rare. The buyer doesn't do writing anything, and but they put that on.
Well, thank you for that question because it was something that I was going to bring up is that we don't just see this in escrow. Many times I will have an exchanger that, you know, we are getting prepared on a purchase to fund on their behalf and they're getting a new loan and they come in and with that addendum with the changing of the price and we didn't know it. We have to redo documentation. It may have tax implications for them that they forget about sometimes, and it might still be the right thing to do in changing that purchase price, but they didn't tell us, they didn't tell the closer, they didn't tell the lender. And so not only do we have this scenario to deal with, but I always have to look at it and say, okay, you sold for this amount and you were going to buy equal or greater, and okay, you got it reduced down, you got a lower price. That's fine. But do you realize I have to do your documents with the correct information? And by the way, remember, you are not buying equal or greater and you will pay some taxes for this, which is okay if it's the right property, you can make that up. If they're willing to do that, some will say, oh, I forgot. Well, now I have some more money. Maybe I'll buy something else. So there's lots of ramifications of not being told the new terms and conditions or any changes. Sometimes they will add and negotiate repairs. How I do and spend the money on those repairs are then conditioned again on different processes. So it does affect us all the way down the line. It affects everybody. I do want to say one thing, though. You know, that 1 day is so much, you know, some of these things we may have only a 1 day pause. That sounds really, really good, and I'll take it and run with it. But in our world and your world, we all know so many times people are telling us we're leaving town. We're packed. We're walking out of this closing, and you're telling me we're signing at 5 o'clock for you guys because they're in their car. Even that's still, we will feel it. Of course, we're trying to minimize that, but I do know that's your world because it's my world and our world here.
Our world.
But even that 1 day, you know, is much better than the 3 days, but that still it's situational for all of us, even that 1 day.
So I'm still confused about the 1 day. It all depends on what happens, right?
Yeah.
Okay, so we don't really know. So we should probably prepare ourselves for the worst.
Well, typically, if you have a new closing disclosure, you can't close the same day that a new closing disclosure is issued. It has to be the next day if you have to do a new closing disclosure. That's a different item from a condition that kicks you over the limit for the 3 day disclosure. So they're two different things. I know, it's hard. It's hard, believe me. Yeah.
Well, same story. The buyer is always.
Yeah, they're affected.
Yeah.
Yep.
John?
Does this mean that your policy, John, and hopefully the policy of other lending institutions will be that the closing disclosure to the licensee a day or two before that 3 day time when it goes out to the buyer?
Well, I'm thinking if we were doing that, that would just add additional days to the transaction because you can't get that disclosure out till the end. So that just means, oh, I'm going to get it to the realtor 2 days ahead of time. Now, basically, you've made it a 5-day deal. But there's another part to that, and that is that can we legally do that?
Right.
And we are not at this point anticipating giving the closing disclosure to the realtor. We believe title will, of course, be giving the settlement statement for buyer or seller. We are going to come up with a form for the borrower to say, yes, I want you to give the closing disclosure to the realtor. And at that point, we would give it to the realtor the same time that we give it to the buyer. Typically, we're not going to have it done ahead of time in order to get it out.
That was a question that John and I talked about. Is this going, what are the licensees going to be receiving? And so that was our question we discussed this morning. It's a really good one because unless you have authority to, and some people will say yes and some people will say no. So that's kind of your approach at this point. The closing disclosure for the borrower doesn't go to the licensee.
Doesn't go to the licensee.
That's why you need to be familiar that this is.
And people understand that CFPB said that these are all these rules you have to comply to, but they weren't specific. And all they do is tell you if you're not compliant, you're subject to fines and penalties. So it's
Yes.
the gray area and erring on the side of conservative.
And the most wonderful thing is when they send you even an email out explaining something, at the bottom of it, there will be a big paragraph that says they're not responsible for anything they said. It's still your job to look at it and understand the law, even the people that are writing it. It's just lovely.
Yeah.
Will any of this affect your 90% letter?
I don't see how this affects the 90% letter because that's still governed by, the 90% letter is actually something now within our state statutes for mortgage licensing statutes. So for home state, who's governed under state statutes, the 90% letter is actually defined within that statute and also defined within the your contract, the realtor contract. Placing.
As a follow-up, it was suggested maybe a good idea for us to have a class in what to take care of outside of closing. Because I'm sure there will be a lot of instances where something comes up at the last minute, and rather than stopping my clients to their new home in Colorado, we're going to say, well, let's just take that outside of closing.
And that'll be interesting too from our perspective, from the closing.
I can tell you if I asked a federal regulator what the answer would be.
That's right.
Practically, there's even something that was simple as property.
Right.
We all know. I'm going to leave the drapes. I'm going to leave that old couch. They have no real value to anyone else. And so there's obviously, you have to, within your personal property section, say what's going to stay and what's not going to stay. We get into gray areas all the time, like washers and dryers. And the answer is if it's common, you can put it in there and that can go with the home and it's not a big deal. Then you get the one I remember quite a few years ago of the Rolls Royce parked in the garage. No, that's not okay. So there's always going to be some gray area in this. What are the limits of that gray area is going to be really, really hard to figure out. It's a problem. And the biggest thing I worry about is that things that people are all clients, everybody wants to close. I'm leaving town. I've got to get this done. Let's just do this outside. Everybody's happy with that. And they close, and then something else goes wrong with the house later. The roof starts leaking 2 months later. And now they go to an attorney, and the attorney's looking for the letter of the law and everything. And I don't know how that's going to end up. So that's always a hard part in these things that worries me a lot. So, yes?
Just to clarify, you said at first that only the APR changed with any of the fees, that it would put you into the 3-day waiting period. But you also just said if there was a change on the cash to close to the buyer, it would do that as well. So those two.
No, I didn't. Yeah, there's some confusion there, and I understand why. There's three areas of change that affect a new 3-day disclosure. That is changing the APR by more than an eighth, adding a prepayment penalty that wasn't there before, or changing the loan type. Okay. The other thing I was talking about was just, which is still there now, and that is loan approval. The underwriter has to approve the loan for closing, and part of that is verifying the borrower has adequate cash to close. And if you change the borrower's cash to close, it has to go back to the underwriter. That doesn't add 3 days. It means it has to go back to the underwriter to say, yes, we still have enough cash to close.
Yeah, which could be longer than 3 days.
Yeah.
Yes.
Usually not, but could be. Hey, yeah. Any other, yeah.
And it still has to go back to the underwriter if the cash to close is reduced. Yeah.
If it's a reduction in the cash to close, it should not have to go to the underwriter, but it depends upon what is the thing that caused the reduction in cash to close, because we've had situations where I'm going to give you a credit of $2,000 to put a carpet in after closing, and that reduced the cash to close. That's not going to be okay because it's happening after closing. So it depends upon what the thing is, and so I always worry about the broad statement that it wouldn't, but in general, if it reduced the cash to close, that should not be a problem.
You know, John, one thing I think we all need to really focus on now, and we're pretty wary of it already with early occupancy. I think that's going to become a no, big no. Because if you give somebody 3 days to wait and do an early occupancy because they have to get on that house because they're moving, going on vacation, and that U-Haul's in front of that house, they're going to try to persuade you. We've all heard it a million times. But that would be some strong concern for a seller, if I represent a seller, to have someone go in there and say, hey, well, we decided we're not going to like it. We don't like our neighbors or anything to happen. So I hope people take a strong.
It's and you're right. That's a consideration. I think more on your side, and it causes. I've seen a lot of problems happen with that. One of the issues we ran into just yesterday was someone had let someone early occupy with no cost, and they weren't paying any daily cost. Well, that's considered an incentive and is actually specifically addressed in our guides that you can't do that. Now, there is some situations that they just came out, frankly, in the new FHA guide that was just released September 14th, a couple of days ago. There is something that says when builders are doing a reduced rent because they were delayed, the builder was delayed in the process, that there is an ability to do that. But they finally addressed that a little bit. But in the general case, you can't have someone occupy early and not pay any rent or below market rent in order to acquire cash to close. So that can be a problem too. It's really weird in some of these things. The exact same thing as we all know. You're going to get $2,000 credit towards your closing costs, prepaids, and reserves. That's okay. You're going to get $2,000 to put a carpet in after closing. That isn't okay. Who knows why? It's just the way the rules are written.
I had some thoughts of how CFPB affects Alyeska title I wanted to share with you today. Besides the change in the process and the documentation, we have been required, it's called the Consumer Financial Protection Bureau. And so when you enter Alyeska title, you will see that we have implemented some changes. We have a door that closes off the front lobby to the closing and the title departments. And that is because we are now required by these, there's other regulations that are being applied to the settlement agent and to parties to the transaction that we know who is going through our office. We already have a schedule that has your name and your buyer, your seller. So we've got that controlled. But like TRID, our TRID company, they gave an example to protect the consumer. We have to have people log in or controlled, just like a bank. You just can't walk through because of the sensitive information we have in files, and we're working on them in the open there. And an example of that was, this is a true example out of California. When I went to an underwriter meeting, they had the SHRED people come in, and they picked up, like always, they had their uniform and everything, but you know, a few minutes later, after this guy came in and took all this pertinent information to shred it, 10-15 minutes later, another guy came in from the same company, and I said, well, wait a minute. And as it turned out, the first one was bogus and was getting that financial information. And that is why we are having to log in. We will be getting with our SHRED company, all the legitimate employees, and they're going to have to show us who they are when they walk through our environment. And that applies to you. Now,
Gosh, I wish you hadn't told me that.
I know, I was shocked when I went to this underwriter meeting. That was from a title company, right? They thought they were doing the right thing. They implemented the SHRED company because they had a lot of this information, and it wasn't being, you know, they have boxes to go to SHRED and things like that, and it was being taken care of on a very high level, and then they had this happen. And so other nuances for us is that we have to have the consumer has to have the ability to file complaint, and many times filing a complaint isn't really a complaint, but it's clarification after closing. You know, the closer explains everything, and they gave a real life example. The example was out of a state in Colorado where there was a $25 fee to get local tax information, and they didn't, they explained it. The lady says, well, I don't understand what this $25 fee. So the closer explained it, and she said, oh, okay, closed. And then everything was fine. Well, within 30 days, she also went back to the lender and asked the lender to explain it to her. Again, because of the CFPB environment. So 30 days later, she filed a complaint that she didn't understand and still doesn't understand why she was charged $25. And that went on the CFPB website, and they were investigating this. So even if it's explained by, so we now have to keep, have a site, an area that the customer can file a complaint. And like I say, many times it's clarification. You know, they don't remember. A lot of information's being thrown at the customer, but we explain it over and over. Sometimes it's simply clarification, but it is being termed that we have to have a complaint site area, and then we have to delegate and show our conversations, lender conversations. You won't be out of this either, because some of it is things that the lender has required, but if they didn't feel they understood it, then so this is what you have in the CFPB website. So Alyeska has also been undergoing, we have policies that we've had to implement for the protection of the consumer. Our underwriter has, both of them have been of great assistance in, we've had like 35 to 50 new policies in that they're clarifying what our procedures are on many, many matters and how we handle our business as a whole. So this isn't just this change for us. It's been a comprehensive one that I myself and my team have been working on. And our underwriters were 5-star, and we've been told that we are like, 90% ahead of the game. So we're doing it right, and our underwriters have been amazing in helping us comply with all these new regulations. So if you see changes in Alyeska, it's not that we're shutting you out. It's that we're shutting you out. We have my escrow people. I told them they're in lockdown now, so they're not going anywhere. But these are some of the comprehensive scope of what this Consumer Financial Protection Bureau is all about.
And that'll probably flow over to us on some of these things. You've probably noticed if you're in a home state that we had to post notices for the processor area that you can't have anybody back in the processor area on the same lines of thought, that if the processor is looking at someone's tax return and it's open on their desk and someone just walks through and looks at someone else's tax return. That's not a good thing. So we physically have cubicles, so we had to put signs up along there to keep the public out of that area. So
again, the gray area, they say to us, CFPB, you cannot share non-public information about the client. Well, what is that? It could be a loan number. So for settlement statements, we have to send them out encrypted because it discloses the borrower's loan number. It could very well not be it, but they don't define first what it is. So if you start to see a lot of emails that are just, hello, how are you? But it's encrypted, it's because we are just taking the safe bank.
Yep, you will see a lot of that now.
Going back to this sheet here that has the timelines for a typical purchase and refinance at the bottom. 99.9% of the time, we don't care about refinances unless we're personally involved. But I see one really ugly word down here in the refinance timeline that I don't see in the upper one. This seems obvious. I don't want to freak anybody out, but there hasn't been any sort of provision for a built-in opportunity for rescission introduced in a typical purchase. Now, is there because of this new process?
no, right of rescission is something specifically that's been instituted, I don't know, what was it, 10, 15 years ago? And it's 3 days, and that's a little confusing because this is 3 days also, but they're not related at all. That's a 3-day right of rescission where the customer has the right to cancel the transaction. And frankly, that's always a difficult thing because at that point, we as the lender have to refund them any costs they paid. If they just for any reason say, oh, I don't want to do that refinance, you got to give them back their appraisal money. You have to give them back, anything that they put out in that and cancel the transaction. But that doesn't relate to this. Only refinances, yeah. And that's still in effect and is still out there, yeah.
Did you want them to watch the video?
Do you guys want to, it's not a video, but there's a little audio clip
Audio.
from National Association of Realtors. And Russell has been sitting here waiting patiently to hit the button to play it. It's about an 8-minute clip, so why don't we go ahead?
On how we feel with all generations, including if you don't know this in front, a host of regulations. General Counsel Katie Johnson helps us sort through complex issues in time. She's responsible for considering programs, policies, and activities.
It is.
And make sure.
Yeah, it's just audio.
It's just audio, and it's awful. I'd say cut it off. Yeah, it's the source. It's not the volume. So.
Thank you all for coming today.
If you have any other questions, as we get more clarification, we will give it to you. And we do appreciate feedback of issues and problems and questions, because oftentimes the questions other people have also. So it's helped us.
Yeah, you don't have
Contract might be written on October 1st, but they don't go into the bank and make an application. Then application. Yeah, so this is not 3 days ahead of time. CD comes out 3 days ahead of time. This comes out at the end. That's the tax.
Just remember all the strategies.
What's it for?
No, it's about you guys I'm worried about. You're already locked in there. Yeah, bound to get problem. Yeah. You can't come out and talk about that.
I know. Really specific things, I think if you assume it's anything, we're all better off to have stuff early.
And then
No, I get my coffee. I know some people do. I know some people that come into your office. They say you've got enough coffee. Yeah.
I think it's better to show the positives. You will close disclosure 3 days ahead of the closing date, so you'll have time to look at that and make sure everything's right. Something, when you look at it, you say, oh my God, that's price wrong. You know, then that could be a problem. Should not be.
If we don't know about it overnight, these fees cost like $175 or $90